42 years of marriage, 2 rental properties built together, a medical practice that supported 3 generations, a retirement account that had survived 2 recessions. 14 months of a second marriage cut all of it in half. I do not mean cut emotionally. I mean cut by court order. I mean cut by operation of law. I mean cut in front of 2 adult children who sat in my courtroom and watched the inheritance their mother had spent 42 years building disappear into a legal structure they did not know existed. My name is James Harlow. I served 28 years on the bench, presiding over probate, estate, and elder abuse cases at the trial court level. I read the petitions, I heard the testimony, I signed the orders, and I watched, ruling after ruling, how the law arrives only after the damage is irreversible. The deed has already been signed, the account has already been emptied, the new marriage has already occurred. By the time the case reaches a judge, all that remains is to record the loss. I am no longer in a position to issue rulings. I am in a position to explain how this happens, before it happens to your family. The case I am going to describe is one I entered the final order on in 2018. The names have been changed, the structure has not. I am going to call the man at the center of it George Whitfield. George was 73 years old at the time of his second marriage. He had been married to his first wife, whom I will call Eleanor, for 42 years. They had 2 children together, a son, Thomas, then 40, a daughter, Karen, then 37. Eleanor died of congestive heart failure in October of 2016. She was 71 years old. Eleanor and George had been the kind of professional couple that a small town builds around. Eleanor coordinated the front office of the practice for 29 years. She knew the medical history of 3/4 of the patients by memory. When she was diagnosed, the practice closed for 3 weeks. Patients sent food. The grocery store down the street put a card in the front window. 42 years of marriage had produced not only a balance sheet, but also the kind of social standing that does not appear on any inventory and cannot be inherited by anyone. Thomas and Karen flew home for the last week of their mother's life. Karen told me in deposition years later that her father did not weep at the funeral. He wept 3 weeks afterward, in the parking lot of the medical office, the morning he closed the practice for the last time. I want to describe what George had built with Eleanor over those 42 years, because the value of what was at stake in this case is the value of an entire working life. George was a retired family physician. He had practiced for 34 years in the same county. Eleanor had been a nurse practitioner in the same office until she retired at 67. Together, they had paid off their primary residence, valued at the time of the second marriage at $710,000. They had acquired 2 rental properties, 1 duplex and 1 single-family home, with a combined value of approximately $890,000. George held a vested equity interest in the medical group he had partnered with, valued for buyout purposes at $460,000. His retirement account held just over $1,400,000. There was a brokerage account with $620,000 in it. The total net worth of the estate George brought into his second marriage was, by the inventory eventually filed in my court, approximately $4,160,000. George met the woman I will call Margaret Davenport 8 months after Eleanor's funeral. They were introduced through a mutual friend at a charity dinner. Margaret was 61 years old. She was a widow herself. Her own husband had died of a stroke 4 years earlier. She was articulate, attentive, and patient with the kind of grief that does not announce itself. They began dating 5 months after the introduction. They were engaged within 9 months. They were married 14 months after Eleanor's death. The wedding was a Saturday afternoon ceremony at the country club where George had played tennis for 31 years. Margaret had been a member at a different club in the next county. She joined the new club a month before the wedding. There was nothing unusual about that decision. Couples make joint memberships. The detail I want you to register is that within 14 months of Eleanor's death, every social context George had built with his first wife had been quietly replaced or supplemented with a context that included his second wife. This is not a criticism of Margaret. This is an observation about how second marriages of this kind generally proceed. The replacement is gradual. The replacement is not malicious. The replacement is, in most cases, the natural consequence of two people building a new life. The legal consequences of that replacement are what most families do not anticipate. The wedding was small. 23 guests. Thomas and Karen attended. They did not object. They had concluded, between the two of them, in the months leading up to the wedding, that their father deserved companionship, and that any objection on their part would be heard as an objection to his happiness. They made what most adult children of widowed parents make in the first year after a parent's death. They made a private decision to trust. Now I want to describe what happened legally during the 14 months that followed the wedding, because the speed at which the structure of George's estate was rewritten is, in my experience, the most underappreciated feature of these cases. 4 months after the wedding, on the recommendation of a financial planner Margaret had used for years, George retitled the deed to the primary residence. The deed was changed from sole ownership to joint tenancy with right of survivorship. The financial planner explained that this would simplify probate and ensure that Margaret would not be displaced from the home if anything happened to George. George signed the new deed at the office of a local title company on a Wednesday morning. The notary who notarized the signature did not explain to him, and was not required to explain to him, that joint tenancy with right of survivorship transfers the entire property to the surviving joint tenant the moment the other joint tenant dies. The deed does not pass through the will. The will has no jurisdiction over a property held in joint tenancy. The house left George's estate the moment he signed that deed, even though he was still alive and still living in it. 6 months after the wedding, George logged into the online portal for his retirement account and updated the beneficiary designation. He removed the children, who had been listed as 50-50 contingent beneficiaries since 2004, and named Margaret as 100% primary beneficiary. He did this on a Saturday afternoon. The change took less than 4 minutes. He did not consult an attorney. He did not consult his children. He believed, and he was correct, that he had the right to designate any beneficiary he wished on his own retirement account. What he did not understand, because no one had ever explained it to him, was that the beneficiary designation on a retirement account supersedes the will. The will controls only what is left after every titled and designated asset has been distributed by its own document. The day George updated that designation, he transferred $1,400,000 out of the reach of his existing will. 9 months after the wedding, George executed a new will. The will named Margaret as the primary beneficiary of his residuary estate, with the children to receive a small specific bequest of personal property and a one-time cash gift of $50,000 each. George had been counseled by an estate planning attorney, but the attorney was an attorney Margaret had introduced him to. The attorney did not represent the children. The attorney was not asked and did not volunteer to explain what the children would have inherited had George not signed this new will. The new will was executed in compliance with every formality of the state. There was no defect. There was nothing to contest. 14 months after the wedding, on a Tuesday morning in March of 2018, George had a heart attack at the breakfast table. Margaret called 911. The paramedics were unable to revive him. He was pronounced dead at the regional hospital at 10:41 in the morning. He was 74 years old. Thomas and Karen flew in for the funeral. The wake was held at the family home. They were treated with kindness. They were told that arrangements would be made. They returned to their respective cities with the assumption, common to most adult children of widowed parents, that the legal process would now follow a course they could roughly anticipate. They had read their father's old will, the will from 1999, after their mother's death. They believed they would each inherit a substantial portion of their father's estate. They did not know that their father had executed a new will. They did not know what beneficiary designations were. They did not know that joint tenancy existed. If you have a parent who has remarried in the last 5 years, or if you yourself have remarried after the age of 60, the conversation I am asking you to consider is not one you can postpone. The structure of an estate after a second marriage is not the structure most families assume. The will is not the controlling document for most of what is owned. If you find this useful, I ask that you share it with whoever in your family needs to hear it, and that you subscribe so I can continue to do this work. The comments under these videos are read. Patterns repeat, and patterns that repeat in writing are patterns I can address in future videos. Now back to George Whitfield and to the inventory hearing that took place in my courtroom 7 months after his death. The inventory of the estate was filed by the executor named in George's new will. That executor was Margaret. The inventory listed the medical group equity interest, valued by independent appraisal at $460,000. It listed the 2 rental properties, valued together at $890,000. It listed the brokerage account, valued at $620,000. It did not list the primary residence, because the residence had passed outside of probate by joint tenancy. It did not list the retirement account, because the retirement account had passed by beneficiary designation directly to Margaret. The inventory listed approximately $1,970,000 in probate assets. The total estate had been $4,160,000 at the time of the second marriage. The portion of that estate now subject to the new will was less than half. The new will, when its terms were applied, distributed the residuary estate as follows. Margaret received the residuary, less the specific cash gifts to the children. Thomas received $50,000. Karen received $50,000. The medical group equity, the rental properties, and the brokerage account passed, by the terms of the new will, to Margaret. The house and the retirement account had already passed to her by their own controlling documents. By the time my final order was entered, Margaret had received in total approximately $4,060,000. The 2 children of the first marriage had received between them $100,000 in cash and a small inventory of personal items. I have presided over a number of cases like this one. The detail I remember from this particular case is what Karen said to her brother in the gallery after I read the final order into the record. She said one sentence. I have been quoting it ever since. She said, "The will we read after Mom died was just a document. None of it was real." Thomas was silent for the rest of the proceeding. He spoke to me briefly in the corridor outside the courtroom after the order had been signed. He told me that what disturbed him was not the dollar amount. The dollar amount was a fact, and a fact could be absorbed. What disturbed him was that he had not understood, at any point during the 14 months of his father's second marriage, what was actually being decided. He had assumed that the conversations he was not part of were conversations about flowers, about furniture, about which of Margaret's adult children were going to be invited for Thanksgiving. He had not assumed that those conversations included the redirection of his mother's life work. He told me he wished someone had explained to him at the time of the wedding what a beneficiary form was. Nobody did. He asked me on the way out of the courthouse whether I thought his father had understood. I told him I had presided over enough cases to know that most men in his father's position did not understand. They believed they were doing what their attorney told them was sensible. They did not understand that the attorney was not their family attorney. They did not understand that the financial planner had not been retained to protect the children. They believed, because they were honest men, that everyone in the room was acting in the best interest of everyone else in the room. The law does not require that anyone act in the best interest of anyone other than the person who has retained them. Margaret did not commit fraud. Margaret did not exercise undue influence in any sense that the court could find. Margaret encouraged her husband to make decisions he had the legal right to make. The financial planner who recommended the joint tenancy did not commit malpractice. The attorney who drafted the new will did not commit malpractice. The notary who notarized the deed did not commit malpractice. Every individual in the chain acted within the law. The result, however, was that a 42-year marriage and the estate it had produced was redirected by 3 documents executed in 14 months. I want to give you the 4 rules that, in my experience on the bench, would have prevented this outcome. These are not theoretical. These are the 4 rules that, if George Whitfield had followed them, would have left a substantially different estate to his children. Rule 1. The beneficiary designation is the controlling document on retirement accounts, life insurance policies, annuities, and most pension benefits. The will does not override the beneficiary designation. If you have a retirement account and you remarry, you must understand that whoever is named as the beneficiary on the account form will receive the entire balance the moment you die, regardless of what your will says. If you intend to leave a portion of that account to your children, you must list them on the beneficiary form itself. The form, not the will, is what the plan administrator will follow. Rule 2. The deed is the controlling document on real estate. Joint tenancy with right of survivorship transfers the entire property outside of probate at the moment of death. Tenancy in common does not. If you intend for your children to inherit any portion of your home, you must own it as a tenant in common, or you must hold it through a trust. If your deed has been retitled into joint tenancy with your new spouse, the will has no jurisdiction over that house. None. Rule 3. The marriage itself partially revokes a pre-existing will in most states. The will you executed before the wedding is a will the law will not fully enforce against your new spouse. The new spouse has, in most states, a statutory elective share that operates regardless of what the will says. The elective share cannot be defeated by a will alone. The elective share can only be waived through a properly drafted prenuptial agreement executed before the marriage with independent counsel for both parties. If you marry after 60, and you do not sign a prenup, you have, by default, granted your new spouse the right to claim a fixed percentage of your estate against any will you have or will ever sign. I want to add a clarification on the elective share, because the percentage varies by state, and the variation matters. In some states, the elective share is a flat 33% of the augmented estate. In some states, it is a sliding scale that increases with the length of the marriage, beginning at 3% in year 1 and rising to 50% after 15 years. In a small number of community property states, the structure is different again, and the surviving spouse may already have a vested half interest in marital property by operation of law. The point is not that the percentage is the same everywhere. The point is that there is a percentage, almost everywhere, that the will cannot reduce. You must know what the percentage is in your state. You must know what assets it applies to. And you must understand, before you sign a marriage license, that you are agreeing to that percentage by default. Rule 4, and this is the one most families overlook entirely. After the second marriage, you must conduct a complete inventory of every titled asset you own and every beneficiary form attached to any account. The deed to your house, the title on every vehicle, the beneficiary on every life insurance policy, the beneficiary on every retirement and pension account, the beneficiary on every annuity, the signature card on every joint bank account. Each of these documents controls the disposition of an asset independently of the will. Each of these documents must be reviewed, individually, in the context of the new marriage. If you have not reviewed every single one of these documents, You do not know what your estate will look like the day after you die. The will you signed last week tells you what you intend. These other documents tell the truth about what will actually happen. I will close with a final observation, drawn from the cases I sat on for 28 years. The reason these outcomes are so common is not because the law is hidden. The law is public. The reason these outcomes are so common is because most families do not think of a second marriage as a financial event. They think of it as an emotional event. They think of it as a private decision. They think the structure of their estate is governed by the will they signed many years ago, and by the conversations they have had with their children. None of those things are correct. The structure of an estate is governed by the documents that title the assets and designate the beneficiaries. The conversations with the children are not enforceable. The old will is largely overridden. The new spouse has rights granted by statute that operate without anyone's permission. By the time you understand this, the documents that would have protected the children of the first marriage are documents you no longer have time to sign. I want to mention one further detail from the Whitfield case, because it is the kind of detail that does not appear in any legal commentary, but that determines whether a family recovers from this kind of outcome. After the final order was entered, Margaret listed the primary residence for sale. She had no intention of remaining in a house she had lived in for less than 2 years. The house sold within 10 weeks. The proceeds, after the mortgage was satisfied, came to approximately $640,000. That money belonged to Margaret. The home Eleanor had decorated. The home where Thomas and Karen had grown up. The home where the family Christmas tree had stood for 37 years. Was sold to a couple in their 40s who renovated the kitchen. The children were not given the opportunity to purchase the house. They were not legally entitled to that opportunity. The house had passed to Margaret by joint tenancy, and the disposition of it was hers alone to decide. If anyone in your family is widowed and considering remarriage, or has remarried in the last 5 years, send them this video. It is not a video against remarriage. It is a video about preparation. Preparation is what most second marriages do not have, and preparation is the only thing that protects an inheritance once a marriage license has been signed. This is former Judge James Harlow.